living with your spouse. He's down.
Oh, he went out on his first shot.
Oh, go ahead, Kitty, and that.
Yeah.
It's on his face.
Emergency medical services.
Radio. Please.
It's just my normal. They use 8,000.
Normal rip.
Yeah.
Can't appeal a motion.
All right, we have one more matter. It is in the matter of Christopher. Is it Joseph?
Yes.
It's this writ is misspelled. And Houston Smith. And that's you.
Yes, sir.
And Mr. Gertz here is.
All right, guys, this courtroom turned explosive the second the judge focused on one simple but deadly contradiction. Norbert Pastor was now claiming that diabetes had completely ruined the validity of his breathalyzer results, and because of that, his guilty plea should be challenged. His attorney argued that if Pastor was diabetic, the alcohol reading could have been artificially high, making the entire DUI case deeply flawed. But there was one massive problem standing in the way. According to the police report, Norbert Pastor told officers he was not diabetic. That contradiction hit the courtroom like a hammer. Suddenly, this was no longer just about medical records. It became a brutal fight over truth, credibility, and whether the defense was trying to rewrite history after the fact.
Your attorney and the state's attorney is present. There is a motion or an application for writ of habeas corpus requesting a reasonable bond with the inference that the 800,000 was not reasonable. At least one man's opinion says that. Let me look at this circumstances. You know what I need to
There.
public safety report?
Look. There.
I've got a public safety report here.
Thank you, Ellen.
You're up.
Good move, quickly.
And the people too. But when I'll put it on the website, please.
This is all he's been ever arrested for?
Yes, Judge.
That's true.
Yes.
Yes.
The defense tried to push forward with medical records from October 7th, claiming they showed diabetes or at least serious prediabetes. Counsel insisted this created a manifest injustice, comparing it to discovering DNA evidence after a wrongful murder conviction. It was a dramatic comparison, but the judge immediately cut through the noise. He asked the most important question in the room. Does the doctor actually call him diabetic? Or does the report only say prediabetic? That distinction was everything. The defense kept arguing that prediabetes was basically the same thing, but the judge refused to play that game. In a courtroom, close enough means absolutely nothing. Facts win. Assumptions get destroyed.
You speak up. Okay. Sometimes help me on that. All right. Generally, bonds are set based upon criminal history and circumstances of the offense. And then other circumstances become an issue. That is, if a bond is going to be posted, the ability to follow up with the requirements of a bond. Where do you live? I know where you're residing now, but do you live in Groves?
No, sir. I live in Needleland.
You previously lived in Groves.
Yes, sir.
I grew up in Groves. This is not what Groves stands for. All right.
Then the prosecutor stepped in and drove the knife deeper. He pointed out that if the police report showed Norbert Pastor himself denied being diabetic, then how could prior counsel be blamed for not raising a diabetes defense? That was the entire ineffective assistance argument collapsing in real time. If the defense lawyer reviewed the report and saw the client deny diabetes, why would that lawyer investigate a diabetic breathalyzer issue? Unless there was proof that prior counsel had clear medical evidence proving diabetes, there was no failure. The prosecution's position was simple and brutal. You cannot blame your lawyer for not chasing a defense your own client appeared to deny.
I think I see here why Imagine, who set this bond, originally?
And Judge Sharon, Judge.
The room. I see why he would have set this. According to the probable cause affidavit here, law enforcement obtained warrants to get certain accounts that you were associated with to something called KIK Messenger, which I'm not real familiar with. But what they recovered, the police recovered, was a large amount of what they claim is child pornography.
Then came the judge's most devastating moment. He asked a question that completely cornered the defense. If a defendant tells police, "I'm not diabetic," can he later return to court and demand the breathalyzer be excluded because he actually was diabetic? The judge was visibly frustrated. He mocked the idea that officers should somehow ignore direct statements and act like mind readers. Should every officer assume every suspect is secretly lying about their medical condition? The logic was crushing. If the officer truthfully heard that statement, then blaming the system later looked less like justice and more like manipulation. The courtroom tension was brutal because nobody had a clean answer.
That was associated with you here. The probable cause affidavit states that the writer, which is Detective Perkins of Needle PD, observed 40 images and videos depicting child pornography, 31 of the videos depicting children being sexually assaulted. Further, according to this statement, the writer, Detective Perkins, the author of this probable cause affidavit, observed the suspect, you, to have uploaded photographs and videos of yourself to the account. And he was able to verify you by comparing the videos to your driver's license. Also, and
the defense still refused to surrender. They argued they were not trying to erase the whole case, only the breathalyzer results. If the machine was used under the wrong conditions, they said those results should be excluded completely. They compared it to standard DUI mistakes, like failing to properly observe a suspect before testing. But the judge shut that down instantly. He explained that a technical observation failure is not the same as a defendant allegedly denying diabetes, and then changing the story later. One is procedure. The other is credibility. And credibility was collapsing fast. The judge made it painfully clear. This argument was hanging by a thread.
Probably the most disturbing part of this. I also, according to the detective, it was observed that you have communicated with other individuals on KIK, this system, communication system, about your sexual fantasies, which included sexually assaulting and murdering infant children. Can you explain that?
Judge, I'm going to ask him not to answer that question.
All right. Well, anything else?
No, other than I don't even know if the bond is sufficient as it is. But
One of the most disturbing things I've read in my career, and I've seen it all, I thought. And
even with serious skepticism, the judge agreed to grant a hearing. He wanted the officer present. He wanted the treating doctor present. He wanted real testimony instead of legal smoke and mirrors. But he also delivered a final warning that landed like a punch. He said he could not imagine any serious judge throwing out a breathalyzer if the defendant himself told police he was not diabetic. That statement was devastating. The defense now had one final shot to prove this was not a desperate last-minute escape plan. The hearing was scheduled for April 30th at 1 p.m., and the message from the bench was crystal clear: bring real proof, or this argument gets buried for good.
number one, child pornography continues to be abusive to the child. It continues to victimize children when it's out there. Child pornography is bad enough in its very essence. But when someone professes to, let's see, professes sexual fantasy of sexually assaulting and murdering infant children, that puts it into the potential harm and jeopardy of others in a new light. I don't think, and I've been a part of, from the Jamesburg murders to all types of crimes, but I don't think I've ever read such a horrifying and concerning statement about someone's thoughts, a human being's thought that murdering children would be amusing. Well, that's the inference. $800,000 is, I'm not lowering it. Judge DeRuin, I find, based upon the circumstances of this case, a fair determination. But if you happen to be able to post this bond, we have to have a hearing so that conditions of release would be appropriate based upon these circumstances, which would be a long list plus a list that would include all thoughts I would have to ensure that the safety of children could be preserved if you were released. And it would include at least home confinement, no access to internet. Are you married or single?
I'm married.
Sir?
He's
Yes.
married, Judge.
Yes,
Okay,
sir.
any children? Do you have any children? Okay.
No, sir.
Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Well, he went down on his first shot.
Oh, go ahead, Kitty, and that.
Yeah.
On his face.
Emergency medical services.
Radio. Please, please.
No.
He passed out.
Just relax, relax.
Radio.
Thank you. Can I get up? That's good.
Don't get up, just sit.
Just sit on the floor. Sorry, I apologize. You sit right there.
Where's he bleeding from?
No, he
He keeps head
hit
up.
his face first, Judge.
I'll
No, luckily he didn't do that, but he hit his face first. So.
Need some medical services. Thank you. Yeah, he's bleeding.
Yeah.
From face wound.
We're not gonna let him.
All right.
The jury. Are you ready to go?
All right, we are in recess on this matter right now.